My lord, I
Yes.
beg to make a mention from the hearing list, my lord.
Hearing list.
Yes, my lord.
Okay.
Item number 3, RFA 6 of 2024. Here I am appearing for the respondent number 2, and the matter is fixed for today. However, the learned counsel for the appellant has requested me to, has informed me that he has some, he's indisposed. So if the matter may be taken up after the vacation,
After the vacation,
my lord.
at the request of the learned counsel for the appellant, list this matter again after the vacations. Yes, madam.
Yes. My lord, making a mention regarding item number 1 of part 2.
Item
Number 1 of part 2.
1.
Yes. My lord, the petitioner counsel, Mr. Jordan, is out of station. So as per his request, may the matter be kindly fixed after vacation.
At the request of the learned counsel for the appellant, let this matter be listed after the vacations.
Acknowledgement.
Item number 2.
Huh? Item number 1 of hearing list has been mentioned. Item number
For motion, item number 1.
No, yes.
My lords, in item number 1, the conducting counsel, Mr. Lalpian Felachongtu, is out of station, and he had requested me to pray for an adjournment, my lord, for Thursday, my lord.
Thursday.
This is WPC 75 of 26.
Is the writ maintainable? Huh?
I have no idea, my lord.
Okay, at the request of the learned counsel for the petitioner, comma, at the request made on behalf of the learned counsel for the petitioner, comma, who is stated to be indisposed, comma, list this matter again on Thursday.
Obliged, my lord.
Item number 2.
Yes?
My lord, this matter pertains to a suspension of a village council, my lord, in the Lai Autonomous District Council in Mizoram, my lord. Now, my lord, the petitioners in this case, my lord, they are elected members of the village council of this particular village council, Sangao, my lord. Now, my lord, if your lordship will see the original notice that was issued against them, my lord, which is at page number 110, my lord. The English translation is at 112. My lord, initially this notification was issued against them. My lord, it says like this. In pursuance of a complaint from Lian Kamlo, President, and Sangyapa, Secretary MNF Sangawan, pertaining to Sangawan Village Council's manner of work and their use of funds, an inquiry commission is established on dated 6th November 2025 upon Sangawan Village Council as per office notification number so and so by the authority granted under LAD so and so, and from this day onwards, the Executive Committee hereby suspends Sangawan Village Council by the authority granted under LADC VC so and so. Now, my lord, this was the first, and thereafter, my lord, if you see the second paragraph, the inquiry commission. So they had set up an inquiry, my lord. Further, the following person is hereby appointed as an inquiry commission. The inquiry commission shall, after considering and scrutiny of the facts observed and known to it, and after investigating the same, shall submit a report. So this was the first notification that was issued. Now, thereafter, my lord, at page number 114, the English translation is at 115. Another notification was issued on the same day, and this was regarding appointment of 3 individuals, my lord, as caretaker VCPs. Now, this notification was initially challenged, my lord, in WPC number 140 of 2025, and on the day in motion notice was issued, my lord, at page number 118. The court had issued a stay order, my lord.
Okay.
Your lordship will see the last paragraph. Having heard the submissions made by the learned counsel for the petitioners, this court find it fit to stay the operation of the imputed order till the next date of listing.
Just a minute.
Now, I'm just giving your lordship the
There
history
were
of this.
three orders. On 6th of November, there were three orders. Which
Correct.
one was stayed?
My lord, the court had only mentioned
Which one was stayed?
impugned order.
Order. Which
Yes,
order?
it only mentioned order, my lord, suspension
then-
order, and also, my lord, orders. My lord, your lordship, this is the second last paragraph. It says like this: the learned counsel for the petition has further prayed for the suspension of the said impugned orders till the.
Okay,
So
and then?
this was a typing error, my lord. And the
Then?
next page, my lord, and thereafter, my lord, at page number 120, the case was finally disposed of. Your lordship will see at page number 125, paragraph number 7. In the instant case, so my lord, at the stage of suspension itself, the case was taken up, my lord. This is the point I want to raise. And it says like this: in the instant case, it appears that the petitioners did not know the contents of the said complaint made against them, nor does there appear to be a public notification appointing a commission to inquire into the said complaint. It also appears that a report of the findings of the commission under section 10(1) of the LADC Village Council Act 2010 was not furnished to the petitioners. Furthermore, the petitioners were not given an opportunity of being heard when the inquiry proceedings were drawn against them, which resulted in an impugned suspension order dated 6/1/11/2025. This court therefore finds that the procedure in which the impugned order dated so and so was issued was done without following the principle of odi alteram partem, and therefore finds it appropriate to quash the impugned order dated 6/11/2025. This court also finds that the instant writ petition is also squarely covered by the cases cited in the view so and so. Now, my lord, immediately after this, the court had also made a direction, if your lordship will see it, paragraph 8. Upon quashing of the impugned order dated 6/11/2025, the suspended village council petitioners are allowed to function as a village councils, and upon the resignation, so my lord, this was the previous precedent. Upon the resignation of the president number 4, respondent number 4, the respondent numbers 1 to 3 are directed to proceed as provided under section 8 of the LADC Village Council Act 2010. Now, section 8, my lord, talks of re-election and reappointment of a new village council president. So now the case proceeded accordingly, my lord, and if your lordship will come to page number 131.
31.
Yes, this is notification dated 6th April 2026.
Yes.
It says like this, my lord. As the majority of the members of the Sangha 1 Village Council no longer had confidence in the then Village Council President, it became necessary to elect a new Village Council President. Accordingly, in absence of any opposition, Pu H. Thang Nona of Sangha 1 was elected as the new Village Council President. The election of the President was conducted in accordance with Section 9(2), Chapter 2 of the Lai Autonomous District Council Village Councils Act 2010. Now, my lord, he was appointed on 6th April 2026 and on 13/5/2026, my lord, which was just around a month after he was appointed, my lord, a complaint was submitted, my lord. We'll see at page number 132, and it goes on till 133. And if your lordship will kindly turn to page 133.
33.
Yes, 130. Now, my lord, this complaint was written by 3 members of the MNF party from Sangha 1 unit. They are not members of the village council, my lord. They had written this complaint, and their first complaint, my lord, was this. If your lordship will see the translation at 132A, the 1, it says like this, my lord. The present administration led by Pu H. Thang Nona and his colleagues has been highly incapable of properly administering the village. The elected village council members and the village council secretary have been removed and excluded, and the administration is being run by only 50% of the members. Now, I will show to your lordship that this is not accurate. This is not correct, because Sangha 1,
Anyway, then what happened? They made a complaint. Then what
they made a
happened?
complaint, then show cause notice was issued to us, to the petitioners as well as the other members. This is the show cause notice at page 136. And the translation is at page number 136A. And then we made a reply to this show cause notice, my lord.
Okay.
And then, my lord, at
You were asked to show
139A,
cause. Huh.
at 139A, the respondent numbers 1 to 3, they stated like this, my lord. This is one of the impugned orders, my lord.
Inquiry officer.
Yes,
Inquiry commission.
Inquiry commission was set up, but, my lord, if your lordship will see the first part, The show cause, although the village council president and certain members, my lord, we'll see the last sentence in the first paragraph. Although the village council president and certain members submitted their reply within a stipulated period, the executive council committee found the response unacceptable. Simple, unacceptable, and then thereafter, my lord, your lordship will see the next page. Your lordship will see at page 148. My lord, same thing was mentioned that the hereby it says like this. In the first, it says like this. As the executive committee found the explanations submitted in response to show cause notice unsatisfactory, inquiry commission was set up. Then second paragraph, accordingly in exercise of the powers conferred by so and so, the executive committee of the Dalai Autonomous District Council hereby places the Sangha 1 village council under suspension with immediate effect. Now we are challenging these two, my lord, because the reason we are challenging this, my lord, and in fact, my lord, there is a long line of cases challenging suspension of village councils in the LADC. Now, let me tell your lordship what happens usually. Whenever there is a party, my lord, in the LADC, let's say the party is an MNF. My lord, if the village council is an election, are members of the Congress party, my lord, then what will happen is they will suspend that village council. And whenever there is Congress in the center, my lord, they will suspend the MNF. That is what has been happening. And because of this, my lord, there's a long line of cases, my lord. And all these cases, they have been challenged in this court and they have all been allowed. This is one history I want to say, my lord. And this also is similar, my lord. This was also politically motivated. Your lordship must have already seen that the complaint was written by MNF people. Now, our first line of challenge, my lord, is this. That this show cause notice, my lord, was issued, and the notification was also issued for suspension. Even though they have been suspended, my lord, no reason has been given why the show cause notice has not been accepted. It has only been mentioned, my lord, that it is unsatisfactory. That is my first line of challenge, my lord. And the second line of challenge is, my lord, even though this is only a show cause notice stage, my lord, the show cause notice needs to spell out the penalty that is going to be given. Because suspension, my lord, is a very, very serious step, serious action that has been taken. So because of these two grounds, my lord, we have come to this court. My lord, in this respect, I have given two judgments. I have provided the first judgment. This is with respect to the non-speaking order, my lord. This is from the Supreme Court judgment, MS Kranti Association Private Limited and another versus Masood Ahmed Khan. My lord, if your lordship will kindly turn to page number 4. Page number 4, paragraph number 15, my lord. It says like this, my lord. The necessity of giving reason by a body or authority in support of its decision came up for consideration before this court in several cases. Initially, this court recognized a sort of demarcation between administrative orders and quasi-judicial orders, but with the passage of time, the distinction between the two got blurred and thinned out and virtually reached a vanishing point in the judgment of this court in A.K. Krepak and others versus Union of India and others report in AIR 1970 SC 150. In Keshava Mills Company Limited and another versus Union of India and others reported in AIR so and so, this court approvingly referred to the opinion of Lord Denning in Regina versus Gaming Board ex parte Bentham and quoted him as saying that hearsay as scotch in Rich and Baldwin. The expression speaking order was first coined by so and so. My lord, I'll not go into all of this. Finally, my lord, let me go to paragraph number 21. Next page, my lord. Even though in Harinagar Supra, the decision was administrative, this court insisted on the requirement of recording reason and further held that in exercising appellate powers, the central government acted as a tribunal in exercising judicial powers of the state. And such exercise is subject to Article 136 jurisdiction of this court. Such powers, this court held, cannot be effectively exercised if reasons are not given by the government, central government in support of the orders. Again, in the case of Bhagat Raja versus Union of India and others, the constitution bench of this court examined the question
You
whether
have to show me that while ordering a suspension during an inquiry,
yes,
yet the reasons have to be shown.
Yes, no, the reason, because
This is not a final order acting against you.
because
This is an order of suspension. They want an inquiry.
correct, my lord.
They do not want you in office during the inquiry period.
Correct.
Does a suspension order have to carry a reason?
No, because yes, my lord, because it says like this very clearly in the previous judgment also, my lord, that natural justice has to be followed even at this
Suspension, where is that act? This act you're talking of? Village Council Act?
My lord, your lordship will kindly turn, my lord, to page number 100,
Huh?
page number 100 of this.
100.
Yes.
Where is the power of suspension?
My lord, the power of suspension is at page number, page number 99, ending dissolution of village council. Then it goes on from page number, 100, my lord. 101, lordship has seen the first one in 100. The executive committee may appoint a commission consisting of not more than 3 persons from amongst the officers of the district council to inquire into the affairs of the village council if it considers reasonable on a complaint in writing that the village council is too inefficient.
Which one are you?
My lord will see at page 100.
Page 100, section 13. Down below 13.
No, section, no, that one is suspension, my lord, but your lordship will see first one on the top. The top.
No, that is.
It has to be read with this, my lord. 11 has to be read with this.
Commission can be appointed if it is too inefficient or unable to carry out village administration.
Yes. They have to come to this, they have to show, my lord, that it appears from prima facie that they are inefficient or acting in a manner prejudicial to the interests of the state of the district council or is known to have indulged in corrupt practices. My lord, at least on a prima facie, they have to come to this kind of finding before the suspension.
Presently, you are under suspension.
Under suspension, my lord.
So that is amendment to section 11.
11, my lord. The executive council says like this. As soon as...
Are you challenging the appointment of the inquiry?
Yes.
The initiation of the inquiry?
Yes, we are challenging these two, my lord. We are challenging the inquiry and also the suspension.
Where is that inquiry commission?
My lord, the inquiry commission is at page number 139. 139A is the English translation.
Yes, where is that finding that you think it is inefficient? Where is that finding?
Lordship, I have not received clear instructions regarding that. However, the complaint itself, I think the complaint itself is...
we are not required to go into the allegations level. We are not required to go into the answers given by him. What we are to see is whether, as per the act, there was any decision on your part that we find that it is inefficient.
Lordship, there is no mention in the
Order.
act.
Oh, in the act it is there. If it considers reasonable on a complaint in writing that the village council is too efficient or is unable to carry on the village administration or is acting in a manner prejudicial to the interests of the state or district council or is known to have been indulging in corrupt practice. Page 100, the top sentence. So if the appointment of the inquiry commission, prior to the appointment of an inquiry commission, you must come to a finding. Would merely saying that the response is unacceptable would be prejudging them.
Yes, Lordship. I have not received...
Either
clear
you would say that
instructions
yes,
regarding
these allegations are prima facie. This work has not been done. the attendance sheet shows that if you come to page 132A, that the administration is done by 50% of the members, failure to support the LADC. These are the documents which shows that yes, the LADC has not been supported. They are trying to oppose it. Where is the finding? And during the general election, 3 village council members opposed the official candidate. Can there be a reason to suspend the village council? Kindly say para 2. However, during the so-and-so election, 3 village council members actively opposed the official candidate and enrolled themselves with the ZPM or something and deserted us. Can this be the reason to suspend the village council or to have an inquiry? The village council are their own elected members. Correct me if I am wrong, I do not know the entire process of this, but if they are elected members, they may support someone, they may not support someone during general elections. Can there be a reason to take down the village council?
However, Lordship, there is only one part of the complaint. The other part, point number 1 and point number 3 is relevant.
Elected village council members and village council secretary have been removed and excluded. Where did they have an attendance register before they run by 50% of the members? Cannot be. The voting has to be by a majority.
As of now, Lordship, I have not received.
Can you have it on
instructions
Thursday?
regarding the matter.
Can you have it on Thursday, the office notings as to why this commission has been, whether there was any reason behind the commission being there?
I'll try my best.
The act says that you must first come to a reasonable finding. That reasonable finding. If there is a reasonable finding, suspension is something we are not very interested in staying, given the provisions of section 11. It says executive committee shall, as soon as inquiry proceeding is drawn, order suspension of the functioning. So it has to order your suspension. That cannot be questioned. Whether the inquiry commission was properly, was there a reason behind the inquiry commission being appointed? Give us that on Thursday or Wednesday. Tell us, Wednesday or Thursday?
Thursday, Lordship.
Thursday. Yes, on Thursday we'll consider your inquiry.
Or by that, or till Thursday, let there be status quo till Thursday.
See, it was dissolved in June 4th or comma when 2nd of June. Today is, can be suspended today without there being a reason.
Because otherwise, my lord, they will have to give charge and all. They are asking for the.
No, we'll say a status quo till Thursday.
Till Thursday only, man.
It is not a suspension. If they've taken charge, they've taken charge.
Yes, Lordship.
Is it? We'll have it on Thursday.
I'll try my best. Lordship.
Just have the file notings prior to the order dated 4th of June 2025. The last page, 140A. This is the file number, B so and so oblique 5 oblique 2025 dash LADC LAD. Because otherwise we would not have made up our mind to issue notice. This is an elected body.
Yes, Lordship.
Unless there is something very gross against the elected body, suspension by administrative authorities, it will lead to chaos. Yes.
Yes, Lordship.
Heard Mr. So-and-so General Counsel appearing for the petition, also heard. You appear for all the respondents?
No, Lordship.
You are appearing
1
for
to 3.
respondent number 1, 2 and 3. Stop. The challenge to in this writ petition is to the show cause notice dated 18/5/2026, impugn notification dated 2/6/2026, and a notification dated 4/6/2026, whereby no, full stop, issued, sorry, not full stop, issued by, who has issued all this? Same authority,
Yes.
by the local administrative officer, Lie Autonomous District Council. Full stop. While the notification dated what is 18/5? Notification dated 18/5/2026 required the village council oblique a village council president oblique VCM, Sangao-1 to submit in writing explanation on the matters stated in the complaint enclosed with the show cause notice, the notification dated 2nd of June 2026 constituted an enquiry commission to inquire into the allegations concerning the conduct and administration of the Sangao-1 village council by its president and members. By the notification dated 4th of June 2025, the Executive Committee of the Lie Autonomous District Council placed the Sangao-1 Village Council under suspension with immediate effect. Full stop. 3 caretakers, 3 persons were appointed as caretaker and members respectively by the said notification. Full stop. The Learned Counsel for the petitioner has submitted that on receipt of the show cause notice dated 18/5/2026, an appropriate reply had been filed by the petitioners rebutting the allegations leveled in the show cause notice. Full stop. The Learned Counsel for the petitioner has submitted that the notification dated 26th of June 2025 does not reflect that the appropriate authority had come to any conclusion. Where is that?
My lord, at page number 139. 139A.
Page. Had come to any conclusion that the village council was either inefficient or unable to carry on the village administration or acting in a manner prejudicial to the interest of the state, or that it had been indulging in corrupt practices in the matter of village administration. The Learned Counsel for the petitioner has submitted that in the absence of any reasons being given in the notification dated 26th of June 2025, the appointment of the inquiry commission itself would not stand the scrutiny of law, and therefore the same would require an immediate interference of the court. The Learned Counsel for the petitioner has further submitted that the order dated 4th of June, which was subsequent to the order or to the notification dated 2nd of June 2025, also needs an interference since the village council has been placed under suspension only on the ground that there is an inquiry commission appointed to inquire into the allegations leveled against the council. He has prayed for an interim protection to the village council during the pendency of the petition. The issue notice returnable on issue notice on the respondent number 1, 2, and 3, returnable on Thursday. Full stop. Mr. So-and-so appears for the respondent number 1, 2, and 3 and has submitted that he would make an attempt to have his instructions regarding the appointment of the inquiry commission by the who appointed it? Respondent number?
Respondent number 3, 1 and 3, might 1 to 3, madam. Respondent number 3 issued the notification, madam.
Local administrative department. Who is that? From the respondent number 3 regarding the notification dated regarding the a sequence of events which led to the issuance of the notification dated 22nd of dated 2nd of June 2025. Full stop. Extra copies of the writ petition be since the respondent number 1, 2, and 3 are represented by Mr. So-and-so, formal steps are dispensed with. However, extra copies be supplied within a period of within the course of the day. Full stop. List again on Thursday. Full stop. The prayer for interim relief would be considered on Thursday.
Meantime, madam, status quo.
In the meantime, status quo be maintained as of today.
DP obliged, Lordship.
Obliged.
Item number 3.
This 110. Yes, should we continue or should we come back at 2?
Just, yeah,
Such a small submission,
they
Lordship.
want to make an, they want to seek an adjournment.
Yes.
My senior, the senior counsel is only asking court number 3, Lordship. If this matter may come up on Wednesday.
This
1st
is item
July.
number 3.
Yes, Your
When do you want it? Wednesday.
Wednesday.
Wednesday is a DB day.
DP day.
And Wednesday, perhaps we'll have to go in the afternoon to the consumer forum. We are trying to revive it. Those matters which were pending. It could
Thursday.
be on Thursday at best. Thursday? At the request of the donor council, paying for the petition for the respondent, list this matter again on Thursday.
I'm opposed.
How many matters are there? We'll come back at 2 then. We'll come back at 2.
Yes.
Yes.
Item number 4.
Your Lordship, I was supposed to file my affidavit today. I have spoken with the learned counsel for the petitioner. If this matter can be fixed on Thursday, I will positively file my affidavit by Wednesday.
At the request of the learned counsel appearing for the respondent, list this matter again on Thursday, enabling her to file the affidavit in response to the writ petition. Mr. Swainson, learned counsel for the petitioner, is present.
Item number 5.
Your Lordship, in this matter, I'm appearing on behalf of my senior, Mr. Cesar Ramsana, who cannot appear due to personal difficulties. So, Your Lordship, all the pleadings are complete and all the filings are complete. So, if this matter may be come up this Thursday for admission.
Mr. Swainson, learned counsel appearing for the
Petitioner.
the petitioner has submitted that the pleadings are complete and the matter may be taken up for disposal. When do you want it?
This Thursday, Your Lordship.
Thursday.
The second of July.
List again on Thursday.
Oblige.
Item number 6.
Ms. Swainson appears for the respondent. Yes, sir.
My lord, I have taken steps upon the sole respondent. And this morning, the council reflected in the post is Mr. Kerem Rotfela was here on the morning. And now at this stage, my lord, the TCR has been called for, which has not been received yet.
The Mr. Swainson and the counsel appears for the petitioner.
Appellant.
Cause list reflects the appearance of Mr. K. Emmanuel
Kerem Rotfela.
and Mr. K. Remuruat Fella as counsels for the respondent. Full stop. Service of notice is thus complete. Stop. The trial court records have been called for by the earlier. Which order?
My lord, the TCR has been called in the IA.
In the IA.
Yes, my lord.
Okay. The trial court records as called for in I Civil 109 of 2026 is yet to be received. Stop. List again after the vacations.
Yes, your lord.
Or when do you do it? Yes, tell us. If you want a date, tell us.
No, my lord, it can come up, it may come up after receipt of TCR or after 2 weeks.
List again after the receipt of the TCR. Stop.
My lord, the IA 109 that is seeking for stay of the impugn order. This is a reverse second appeal. The
Between the IA you'll take a new order. Yes.
my lord, there was a concurrent findings below before the line courts below in the trial court and the RFA, whereby the suit property was declared as joint property of the parties hearing. And this court had already formulated substantial question of law on 3/6/2026, my lord. And the main question raised is the question of limitation of law, my lord. And now having the appeal been admitted, my lord, the impugn order may be stayed.
But then the earlier order reflects that the orders are of the order is of 29/1/2026. You have filed an appeal before this court after 4 months. Do you see order at 3606?
Yes, your lordship.
Huh? RFA order is of January. You are filing a second appeal in May.
Yes, your lordship.
Your lordship.
And there is a concurrent finding.
That is true, my lord. But my lord, as per the impugn judgment order of the London trial court, my lord, the suit property which is in continuous constructive and actual position of the state appellant, my lord. It has been now declared as joint property of the rival parties herein.
Okay.
So, as per the impugn order, my lord, the lower portion, half lower portion of the suit property was declared as the owner of the respondent herein. So, unless the impugn order is stayed, my lord, now the appeal having been admitted, it will be just and proper to state.
Yes.
Your
Why
Lordship,
don't you maintain a status quo?
in this matter, before we go into the merit, I have a few queries regarding the admission of appeal.
It has been admitted, he
Your
says.
Lordship, the
If it has been admitted,
the impugned judgment and order was passed on 29/1/2026.
no.
And
The order dated 3rd of June has already admitted the appeal. So now.
yes, my
the
lord, but
question-
before I appear, because the appeal has been filed beyond the statutory period of appeal after 117 days. However, the appellant does not file any condemnation of appeal.
But then that was not. Yes, he's saying that it is. Did you file any condonation petition?
Because the appeal has been filed after 117 days, and no chance has not given to me for filing objection, and no condemnation of appeal also.
When was the this thing? The order is of
The impugned order was passed on
29/1,
2026.
and this has been filed in
29/5/2026.
no 26/5.
Or 26/5, yes.
Huh.
The time spent for applying certified copy and
That has been minused.
Yes, sir, but this should be reflected in the application for condemnation. Because there's no mention in the appeal petition.
Now, since the appeal is already admitted, we will keep your this question of limitation open. We'll reflect it in the order that you have raised a question of limitation. And till the trial court records are received, maintain a status quo.
Your Lordship, I have a few submissions.
that will be for interest of justice.
Because you build something tomorrow, he wins the case, all your built up property will go.
Your Lordship, I have a few submissions here.
Ah.
There was the submission of the applicant regarding bifurcation of LSC number 11 of 1984, which was mentioned in page 15 of the application, para number 7 and 8 of the applicant. Page 15, para number 7 and 8 of the application of the applicant, submitted by the applicant, regarding bifurcation of LSC. seems
Para
to-
7
7 and 8.
of the IA,
Yes.
it is a judgment. LSC, okay.
Para numbers.
Immediately after disposed of.
Page 5. Page 5, para number 7 and 8. Sorry, my lord. It is page 5, para number 7 and 8.
Yes.
Regarding bifurcation of the disputed LSC, seems to be misinformation. Since we do not aware about the bifurcation, as such, I apply RTI and in order
No,
to
but are you taking up any construction activities there?
No,
As of now, no.
as of now.
So, while awaiting the TCR and a final disposal, maintain a status quo. You don't have to give him the possession if you're in possession or anything. Don't construct on it.
My humble,
Don't change the nature
my
of the.
humble prayer is a chance may be given to me for filing written objection. Because we are awaiting the response of RTI.
That is entitled to. Okay. In the IA, you write. Mr. Swenson on at counsel appearing for the opposite parties has submitted that he would be filing his response to the IA within a period of 2 weeks. Good stuff. The list the matter again on 16th of July.
My lord, can it be posted on 23rd?
23rd of July 2026. Full stop. The learned counsel for the applicant has prayed for an interim protection. Full stop. The same will be considered on the next date of listing, the basis of the reply filed by the opposite party. Stop.
Status quo will be maintained. The bifurcation which I mentioned, my lord,
See, your
if it has not yet been bifurcated, that is in my favor. But since the revenue department has issued this determined order for bifurcation, we have an apprehension that some irreparable loss injury may be caused to both the parties. So for the interest of justice, saving the appeal now being admitted, my lord. Only for 2 weeks till the next returnable, the status quo will be maintained.
Your Lord, we are awaiting the response of RTI, so time may be given.
no, we'll give you time till. We have given you time till July. So if you do something to the property in the meantime, it will be it will complicate issues.
My submission was that, my lord, we have an apprehension that the degree of the impugnment order may have already been carried out. But his submission is that it has not been carried out. It is in my favor if it is not been done. So for the interest of justice, status quo will be maintained.
Parties to maintain status quo till the next date of listing, comma. The further continuance of the status quo will be considered on the reply filed by the opposite party. Which was that it should not be continued, we won't continue it.
Will not continue, but as far as my knowledge is concerned, no bifurcation has been taken in respect of the bill.
Very well.
That will be in my favor.
In any case, don't dealienate the property or make a construction on it.
Right, my lord?
That is the status quo we are passing. A status quo as of today.
Right, correct.
We'll reconsider on the next date. Yes, next.
Deeply right.
Item 7.
My lord,
Yes.
so I'm for the respondent. In this matter, paper book was prepared and it was already served to us, so it may be taken up for hearing as usual course.
You received the paper book.
Yes, my lord.
It's been submitted at the bar that the paper books have been for the appellant also. Who statements? Yes, madam, you received the paper book.
Yes.
It is submitted at the bar by Ms. So-and-so, counsel paying for the appellant, and Mr. So-and-so, counsel paying for the respondent, that the paper book has been supplied. Accordingly, list this matter for hearing on. Yes, madam. When would you like for hearing?
Any date, Your Lordship.
On will it be 23rd of July? 23rd of July.
Item number 8.
My lord, this IA 107 is for continuation of delay. I will be filing my objection within 3 days, my lord. I'm for the respondent number 1, the claimant.
However, Lordship, as per the office note, the steps upon respondent number 2 is still awaited.
You are appearing for?
Respondent number 1.
Who is respondent number 2?
I'm the claimant.
And number 2, who is number 2?
Number 2 is the owner of the accident vehicle.
Owner
Of the accident vehicle.
Ms. So-and-so appears for the appellants, full stop. For the applicant, full stop. The learned counsel, Mr. So-and-so, appearing on behalf of the respondent number 1, has submitted that the objection to the IA would be filed within a period of 3 days, full stop. The service report on the respondent number 2 is awaited, full stop. List again on 24th of July 2026. Awaiting service report on the respondent number 2 and allowing the respondent number 1 to file objections to the interlocutory application.
Be applied.
Item number 9.
My lord, my senior Zoram Chana could not appear today, so if this matter may kindly be taken up after 2 weeks.
But you are appearing, tell us what is the matter about.
This is, the I is for continuation of delay for
Ah.
667 days.
667 days. How do you explain that?
My lord, there are certain reasons around that.
Oh, there is no explanation. Anyway, we'll give a senior a chance. When would be here?
After 2 weeks, my lord.
All right,
You have filed your objection.
I have filed.
But Mr. So-and-so learned counsel appearing for the applicant who has submitted that the counsel leading the matter is not in a position to appear today and has sought for an accommodation for 2 weeks. Full stop. Mr. So-and-so learned counsel appearing for the opposite party has submitted that the written objections have been filed. Full stop. Accordingly, list this matter again on the 27th of July 2026. For consideration.
Item number 10.
With your lordship.
Hmm.
Lordship, this is an application for stay of the judgment and order dated 11th of June 2026. Now, lordship, before coming to this, lordship, if I may kindly take your lordship to the appeal memo, lordship. Page number, Roman number 2.
Page?
G, Roman number 2 of the appeal memo.
What is it? Roman number 2?
Yes, lordship. Page number 2.
Huh.
So if I may go through this paragraph number 8, which is the order.
Huh.
Now therefore, this honorable court, taking into consideration of the above statements adduced by the parties and the witnesses and based on the evidences produced before the honorable court, such as the money receipts by the learned counsels for the respondent, prove that the sum of rupees 2 lakhs received and borrowed by Mr. Bimal Chakma were interest money at the rate of 10% per month and were actually borrowed absolutely for the purpose and interest of Mr. Onish Mohan Chakma petitioner. After calculation, the amount comes more than rupees 7 lakhs, including the period of litigation. Hence, the Honorable Court, considering the financial constraint of the petitioner, Mr. Onish Mohan.
You are required to pay 5 lakhs.
So now, Lordship, the reason why we're filing this stay order is because, Lordship, originally the dispute amount is 2 lakhs, Lordship. And out of the 2 lakhs, the petitioner, the appellant herein, have paid back 50,000 rupees.
How much?
50,000 rupees.
Okay.
So now basically the main dispute is 1.5 lakhs. But now, Lordship, the interest which has been charged here is 10% per month, which amounts to 120% per annum, Lordship. And now,
10% per month?
yes, Lordship.
Oh, okay.
So now, Lordship,
But you agreed to it.
we did not.
There
actually-
seems to be some money receipt where you have agreed to it.
So money receipts is regarding the amount which has been borrowed, Lordship, which is 1 lakhs and 1 lakh, Lordship. The receipt is given here as annexure number 3, page number 25 of the appeal memo. So now, Lordship, the reason of filing this stay is because during the pendency of this appeal, Lordship, the respondents have filed a execution before the District Council Court. And in doing so, Lordship, the District Council Court has passed an order on 11th of June 2026, which is given as annexure number A in the IA, Lordship. Which is page number 9 of the stay application. Now, Lordship, if I may go through this.
What is your salary?
Lordship, I'm a ex-MDC, Lordship, a pensioner. I'm receiving an amount of approximately 40,000 per month. So now, being so, Lordship, as per this order, we are to pay 30,000 rupees per month for a period of 17 months. And after
You have to pay 30,000 and another 20,000 would be
deducted after
Deducted.
16 months. Lordship. So such is the condition, Lordship.
30,000 for 16. 16. 20,000.
For 16 months and 20,000 on
And your salary is
40,000, Lordship, approximately, give or take. So now this is the condition, Lordship. When the disputed amount is 2 lakhs and 50,000 has been given back, and now without considering all that, the amount of interest is 10% per month.
So where do you find that 10%? How
10% per month is given in the
how they have reached 10% per month?
Lordship, this is probably an agreement, or this is
How do you say probably, sir? You must know your
so,
case.
Lordship, as per the order, Lordship. So now, if I take your Lordship to page number 1 of the appeal memo, Lordship. Page number 1, Lordship, in paragraph number 3, that the petitioner in his statement adduced that he has not taken the sum of rupees 2 lakhs from Srimati such and such, it is Mr. Bimal Chakma such and such, at the rate of 10% interest. It is just mentioned as 10% interest. It is not mentioned anywhere of being a 10% per month. Other than that, Lordship, in paragraph number 4, it's mentioned here at the rate of 10% per
How
month.
it is done? Yes, sir. How can it be someone takes money on someone else's name, signs his own receipts? Now the burden is on someone else. Am I understanding correctly? A has taken the loan for B from C and signed the receipts. Now B is required to pay back.
My lords, the person who signed the receipt was his brother, the appellant's brother.
Huh.
And then
Where is the authority for him to receive the?
my lords, if your lordship may kindly come to page number 8 of the appeal. Statement of Mr. Bimal Chakma. So he is the appellant's brother, and then he has taken 1 lakh on 11/5/2023, and then another 1 lakh on 8/5/2023. So at that time, the appellant was not was out of station. So and then the 1 lakh was handed over to the appellant's wife, that is to the wife of the appellants. So then, as per instruction from the appellants, so because he was out of station, the another 1 lakh was spent for his election purpose, CADC election, my lords. He was the one who utilized the money.
He took 2 lakhs.
Yes.
He has paid back 50,000.
As
So
per
why
the
should the
statement.
interest? Why should the interest be on 2 lakhs?
Maybe I think it's
Do you
as per the,
do you have
their
instructions? Do you have instructions whether he has paid back that 50,000 or not?
I don't know, my lords, because
from where do you
because,
say
my lords,
you paid
PCR has
50,000?
not been received. PCR has not been received. We cannot say anything, precisely, my lords.
From where do you say you have paid back 50,000, sir?
Yes, Lordship, I'm coming to that, Lordship.
Where is it?
If you just give me, Lordship, just a few minutes, Lordship.
No, this few minutes will not be today. It will be on Thursday. List this matter again on Thursday.
My lords,
Allowing the donor.
my lords, I have one.
Lordship,
And-
I'll mention here.
Huh?
I have one engagement with the revenue department, my lords. On Thursday, we have to go.
Wednesday?
I have some personal difficulty. I have some engagement already, my lords.
Friday?
My lords.
Friday would do. Friday would do.
It's fine, Lordship, but I just found the paragraph here, Lordship. It's
The
reflected in the
paragraph is
district
not-
council court
Where is
order,
the
Lordship.
paragraph? Oh yes, where is the paragraph?
It's in paragraph number 1 of the appeal memo, Lordship.
Paragraph number?
Page number 1 of the appeal memo, paragraph number 4, Lordship. Page number 1 of the appeal memo, paragraph number 4. Now, Lordship, the relevant part is, I'll just go through the paragraph number 4 swiftly, Lordship.
You have filed your objections to this.
So, my lords, I will
Have you filed your objection?
No, my lords. This IA was filed on 23rd of this month, my lords. So, my lords, I will not file my written objection, and if I may be kindly allowed to submit a verbal submission, my lords.
You have you have a pension of 40,000.
40,000, Lordship. And as per the execution order, Lordship, the amount has been deducted from the salary.
30,000. 30,000 from your.
No,
He
Lordship,
does not have a salary. From where will you get it executed? He has a pension.
Yes, he is a pension.
So how can it be deducted from salary? Your
Well,
order
it's-
is wrong.
He was.
The order passed by the district council is wrong. He does not have a salary. Huh?
so now, Lordship, what we're playing,
Page 9, the deduction is to be from the salary.
yes.
So your question is on the amount,
The amount, Lordship.
5 lakhs.
5 lakhs is the
How
amount.
much can you pay?
Lordship, now the
You
pending
you still owe him 1.5 lakhs.
1.5 lakhs, Lordship.
What can you pay him?
Lordship, we can pay him back. I have to consult with my client first,
I
Lordship.
know, but then on Friday you tell us
Yes, Lordship.
what is the amount you are going to pay.
Yes.
All right. Friday is what?
Third.
Third, you tell us what you
Yes,
are going to
Lordship,
pay
yes.
back. Pay back some substantial amount with interest.
Yes.
We'll consider the interim.
But I just have to consult with
1.5 lakhs is admitted, right?
Yes.
So 1.5 lakhs, go for some interest calculation and then pay him something good.
We will come to that, Lordship.
List again on Friday, by which time the learned counsel for the petitioner shall inform this court the instructions and shall inform the court the amount that the petitioner would be in a position to pay to the respondent. That is you say on the RFA, okay? On the IA you say list on Friday for consideration of the interim paid for. Let us see if we can get you some amount during this day.
Deeply obliged.
Item 11.
An application filed by the state of Mizoram for seeking extension of time in compliance of this honorable court order dated 17/3/2023. Now the catch is, Your Lordship, the judgment and order was passed in March 17, 2023. And we were given 6 months time for compliance.
Okay.
Now we are in 2026. Now it will be the case of the respondents that we have been sitting over the case for more than 3 years now. But Your Lordship, if Your Lordship could kindly bear with me, I will explain the details of
show
how
us the order.
Yes.
Order at page 70.
Yes, it starts from page 28 of the application, Your Lordship. The relevant portion will be in page number 70,
I have seen.
paragraph number 23.
You have not appealed against this.
Yes, Your Lordship, we have not made any appeal or review, nothing as such.
Have you filed a contempt?
Yes, my lord.
Contempt is pending before this
Pending
honorable
for
court.
long
In fact,
time.
it is
Since
listed along with.
2023. Since 2023, contempt is pending, no steps at all.
The contempt is also tagged
It's
here,
stepped
is it?
together with
It's clubbed, yes.
So this was filed when?
This,
February.
this was filed
This
in the
IA?
month of February
10th of February.
2026.
Two years?
Yes, Your Lordship.
Even after filing this IA for extension on February, my lord, now we're in the end of June. No steps have been taken by them.
Your Lordship, we have taken steps. It takes time. If Your Lordship could kindly bear with me. I can explain.
2023, 3 years gone, then 2 years more, 5 years. 5 years is a term for something. Are you waiting for the term to be over? Ah. 2 years is too long, madam. Ask for something.
Yes, Your Lordship, in that regard, I will, if Your Lordship could kindly permit me, I can take another instructions in that regard, because regardless of what my learned friend has claimed, we have taken steps, so.
No, we are not going by his statement. But regularization, you have to take steps for regularization or for creation of posts to adjust them. Recent Supreme Court judgment when? 2026, May. Judgment has come. Whether or not here they have been appropriately appointed or whatever, regular.
Manish, yes.
Everything
Yes,
goes, you have to regularize. Now this will be a contempt of the Supreme Court
In
order.
this case, my lord,
Huh?
the petitioners association, they are consisting of about 1,356 members. And there are about 2,700 plus vacancies as on date. And during last year, my lord, the state respondents, the state government had recruited as many as 1,024 casual teachers. Now they have been taking active steps for recruitment of 312 teachers. While not considering the case of the present petitioners, writ petitioners, my lord, they have their own flexi program, ignoring the standing direction of this honorable court. But by way of filing this IA or other ways, my lord, they try to circumvent or delaying the matter while the contempt matter is pending, on the other hand.
No, Your Lordship, that is not the hard truth. In fact, when the contempt matter was placed before this honorable court, it was the suggestion of this honorable court that we have filed the extension, in fact. Yes, it is admittedly that we have taken a huge amount of time, but then it's not a case that I'm not denying that the file is moving in snail pace, but then it's not that we are not doing
the orders in this petition is for regularizing the petitioners.
the petitioner, or in doing so, we are allowed to frame a scheme to which we have framed a scheme. So in our humble opinions, substantial compliance is there, but then in true spirit, we have not completed yet.
There is not even the substantial compliance as submitted, my lord, because after the judgment was rendered by this honorable court, there was a scheme which we thought that we might also be applicable to the case of the petitioners. But the respondents, the cabinet meeting itself themselves had held that we were not covered. So when we brought about the situation to the notice of this honorable court in the contempt proceeding, the director of school education department on 21st August 2024 had filed an affidavit in the contempt petition saying that we were misconceived with the status of the petitioners. So they may also be covered by the scheme which was meant for regularization of CSS employees. But that is in respect of all CSS employees under the state
But
of
they are
Mizoram.
the CSS employees.
No,
But no specific steps.
you are under the SSA.
SSA is
More or
the
less,
CSS.
we are also CSS, my lord. But that scheme was not specifically meant for the writ petitioners, my lord. More or less, with the scheme or without the scheme, they have not taken any steps in furtherance of to comply the direction of this honorable court. All those documents which they have enclosed in the present IA as well as in the contempt affidavit, my lord, they were only pertaining to those steps which have been taken for all over CSS employees, but not for the petitioners. As I have pointed out earlier, my lord, there are more than sufficient vacant posts for absorbing the petitioners, my lord, but they have their own way in interpreting or taking steps while ignoring the case of the petitioners, my lord.
Yes, madam, tell us, this 2 years is rejected. As of now, 2 years is rejected.
I may be given time to.
We will not, 2 years cannot be because
They failed to prefer this extension during the original stipulated period of 6 months for compliance of the order.
you have filed your response to this.
Yes, my lord, I have filed. I have filed on 15 May.
What are your reasons given?
At para 4, my lord, I have stated that during the month from March 2023 to November, they had spent time for considering as to whether an appeal should be filed or not. Ultimately, they preferred not to file an appeal. So at para 5 of my affidavit objection, my lord, I have stated that only in the last portion of in the last para of the para 5 of my para 5, my lord, by way of an affidavit filed on 21/8/2024 of the education director, my lord, they had stated that they might also come under the purview of the scheme of 2024. That means that until this 21/8/2024 was filed by way of affidavit, my lord, they have not taken any steps at all by the authority concerned.
It was under consideration, Your Lordship.
No, my lord. They have said that that is only mere statement and verbal submission, my lord.
Who are the contemnors herein?
The containers were the chief secretary, school education department secretary and director.
Yes, madam, when would you have the instructions? We are going to take this 2 years and then we will be trouble.
Your Lordship, at least
Something reasonable.
maybe next.
Have your
next
instructions
week?
when?
Next week?
Next week is
Oh,
close,
next
so-
week, please. Okay, immediately
This
after vacation,
Wednesday,
Your
my
Lordship.
lord, this.
Your
because, my
Lordship,
lord,
that
this-
we
this has
cannot
been
do
pending
because
for
there
one
is a
month.
change in hands in the incumbents of the
Tomorrow,
secretary. and then
tomorrow there is a holiday, so
My lord,
Wednesday she will not
In
get
the
instructions.
contempt proceeding, my lord, each and every respondents have filed their respective affidavit, and I have also filed my reply back on 15 May. And all the response of the affidavit of the containers, my lord, they're one in the same copy paste, except that their names were different.
One thing you must also consider, we'll have it on Friday if you want,
Yes,
Your Lordship, next, I cannot do that, Your Lordship.
on the next week.
On the next week I can, but
Okay.
not this week.
Have your, go through the contempt petition, have your arguments ready. The secretary cannot simply say I have regularized, yes? The director cannot say I am regularizing, yes? There has to be a process. Now in that process, someone is stopping the entire thing.
I understand.
When the court says regularize them,
Yes, my lord.
can it be that the secretary can sit on his table and say, I hereby regularize everybody?
My lord, in
All
the
the
present
petitions.
case, from the common response of the containers respondents, my lord, no steps have been taken at all by any of them, my lord. As your lordship had already indicated, so far as my humble opinion is concerned, for the case of considering the absorption of the petitioners, my lord, first thing first is that the Directorate of the School Education Department has to make an agenda proposing the regularization of the petitioners, my lord.
Yes, but regarding
They have
this,
not taken any steps
these
at all.
petitioners, which are the documents you had actually moved?
Your Lordship,
Something must have been done.
page number 71, annexure 2
Of the,
of the IA.
page number 71. After this, they said that appeal, no appeal, all that
Yes,
part
yes.
has come up. Thereafter,
Appeal
what
and then
happened?
no appeal.
Then what happened?
And scheme of regularization of CSS employees, SSA, NHM, etc., which is in page
You are
number
referring to
7.
page 77.
Yes, Your Lordship.
How are these petitioners concerned here?
SSA.
Huh?
They are CSS employees under the nomenclature of SSA. NHM or National Health Mission.
Madam,
So this is a blanket scheme for CSS
exactly.
employees.
Suppose we say the respondents are to file an affidavit. Will all the advocates file an affidavit, or everybody who's in the state government will not file an affidavit? It is the concerned person. This is there was a order of this court regarding certain members of the association. Certain members who may be a part of the CSS scheme, but they form a particular association. Few names are there.
Yes.
What has been done with their regard? Or are you trying to move the whole boat?
Yes, a blanket scheme.
That will never come up.
Your Lordship, anyway, if this matter
And
can
there
be...
is-
It will contain thousands of persons.
Thousands of
Never be able to
persons,
form a scheme.
6,000 plus are there.
Then, and here your association has
Only 1,356.
1,356 specific.
Your Lordship, if this can we have this on 14th of July?
We can have it. We can have it on 14th of July, provided you tell us
Yes, I will try to have the concrete.
that what exact steps have been taken regarding the members of the petitioner association without reference to a wholesale scheme.
If that can be reflected in the order also, Your Lordship. So
We
as to
have
be
to know what
precise.
has been done to process the case of the petitioners. We don't know what you are trying to do with all the other people. We are not concerned. Contempt is something where we need to answer, where you need to answer our order. Yes. Heard Ms. Swenson.
Your Lordship, Your Lordship,
Yes.
on 33/2026, on 33/2026 in the contempt order, my lord, this court had already made direction on 33/2026. Last para, 33/2026.
17-2. And 5. There is no order of 33, sir, in the contempt. In the contempt, I don't find any order.
This has been clubbed together, my lord, perhaps in the IA.
Huh?
Perhaps in the IA. Since IA and contempt has been clubbed together. 33. Last paragraph. They have failed to give any report, status report, and they were only delaying the matter, my lord.
Why was that 25/5/2026, the matter was directed to not to be listed before a particular bench? Why?
They have some difficulty, my lord, even on the last occasion, on 19/6 also. For Justice A.M. Kalita, he had recused.
Your Lordship, in fact, this matter was handled by Justice Kalita while he was the additional AG of the... Before the disposal, immediately after the disposal, when whether to file appeal or not was considered.
But then, madam, in May 2026, you had sought time to receive your instructions on this very issue.
Yes, I have received the instructions and I have placed it before this honorable court on that day. But then we cannot take it up. The matter could not be taken up. In fact, I have placed my instructions, which was returned back along with the confidential file.
And what was the order passed then?
The order passed was that the judge has recused, the honorable judge has recused.
So show us, you have the instructions.
I have the instruction.
What is that instruction? Show us.
Okay, so-
They have some confidential instructions which cannot be placed before the petitioners.
That is what they said in the IA also.
This is the kind, I
In spite
don't
of
know
the fact
what's
that
inside.
the contempt,
Just show us the instruction.
this one has been
Instructions
pending since
is not-
2023.
Ah,
There are so many confidential things.
these instructions, madam, do not say anything about the particular writ petitioners.
Your Lordship, it says because it's SSA.
Will not do, madam. You are impressing that will not do. It's not helping. When do you want it? 14th of July.
14th of July, yes. Your Lordship. Or any day in that week.
If it is going to be adjourned, my lord, it may be taken up again at some time during the week commencing from 28th of July,
20.
20, commencing that week, any date.
23rd of July.
Yes, your lordship.
Let's again on the 23rd of July 2026. Full stop. This court notices that there have been several orders in the contempt case number 17 of 2023 and in IA civil number of 28 of 2026 by which the counsel for the respondents in the contempt case oblique applicants in the interlocutory application have been given the opportunity to inform the court regarding the steps taken for compliance of the orders passed by this court in WPC number 128 of 2019. Full stop. It is seen that time again the respondents have placed instructions which relate to an overall action being taken by the state with regard to employees under the CSS scheme. Full stop. It is made clear that this court had granted a certain relief to the petitioners to the members of the petitioner association in WPC 128 of 2019 and did not refer to any overall steps to be taken with regard to employees under the CSS schemes. Full stop. On the failure of the respondents in the contempt petition oblique applicants in the interlocutory application to furnish proper details of the steps being taken for compliance of the orders of this court in WPC number 128 of 2019. This court may require the attendance of the contemners to explain the steps, if any were taken for compliance of the orders of this court. Full stop. It is also noticed that in the interlocutory application, an extension of 2 years is being sought for implementation of the orders of this court, full stop. Consideration of extension of interim orders can, consideration for extension of time to comply with the orders of this court can only be considered once these applicants in the interlocutory application respondents in the contempt case place before this court the exact steps which have been taken till date for compliance of the orders of the court in granting relief to the members of the petitioner association, full stop. List again on, he was asking for some time
23rd.
commencing 20th. So we'll have it on 23rd of July.
Yes, Your Lordship.
Yes, madam. Now we have made it as clear as we can
Yes.
in this order that we need documents to show that these writ petitions are also moving.
Duly noted.
Yes, it will not be a common scheme and 2 years is. Huh? Anything more? Okay. Thank you.
Deeply obliged.